Tack så mycket. Jag tänkte prata på engelska om det går bra. So thank you very much to the organizers for inviting UNHCR to participate in this important conference on, indeed, as we just heard and saw, one of the largest and most protracted displacement situations in the world. UNHCR, I mean, we're very happy to be here to contribute on one aspect, but also really to learn from all of you who are here. And I'm very happy to see from the program that the topic is being addressed from many different perspectives, and that we also have representatives from Palestinian asylum seekers in Norway at the conference, like we said, because we're also looking forward to learn more about your situation in Norway and the Norwegian practice. For UNHCR, this conference is very timely for several reasons. One is because there was a recent judgment from the European Court of Justice in Luxembourg in a case called ELCOT, where UNHCR intervened as a third party. And I will talk a bit about that. And that judgment, plus a previous judgment from a couple of years ago, also by the EU Court of Justice, have, I think, helped provide new interpretation to Article 1D in the 1951 Convention relating to the status of refugees on the status or the inclusion of Palestinian refugees within or outside the scope of the 1951 Refugee Convention. The conference is also timely for UNHCR because we are at the moment, our regional office in Stockholm that covers the 5 Nordic countries and the 3 Baltic countries, is at the moment doing a mapping of statelessness in the 8 countries that we cover. We have consultants who are looking at the national laws, practice, institutional setup in the 8 Nordic and Baltic countries to analyze how these comply with the 1954 and the 1961 Conventions on Statelessness, for which UNHCR has a mandate. So we are coming to this conference both from the perspective of our mandate to supervise states' application of the 1951 Refugee Convention, and also from the statelessness mandate we have for the prevention and reduction of statelessness and protection of stateless persons. So just to recall then that the 1951 Convention relating to the status of refugees contains an Article 1D, which is one of the so-called exclusion clauses in the 1951 Convention, which says that the conventions shall not apply to persons who are at present receiving from organs or agencies of the United Nations other than UNHCR protection or assistance. So this refers to UNRWA. And then the second paragraph of Article 1D says, when such protection or assistance has ceased for any reason, without the position of such persons being definitely settled in accordance with the relevant resolutions adopted by the General Assembly, these persons shall ipso facto be entitled to the benefits of this convention, i.e. the Refugee Convention. So my presentation today is to give a brief summary of UNHCR's interpretation of this provision, which deals specifically with Palestinian refugees under the protection and assistance of UNRWA, and also the interpretation in recent cases by the European Court of Justice, because I think that will also be relevant for the Norwegian practice. The reason why, I mean, just to recall that this provision exists, is that the 1951 Refugee Convention refers to three categories of refugees. One is the statutory refugees who were recognized under Article 1A of the Convention at the time of entry into force in 1951 of the 51 Convention. So they had already been recognized as refugees and were considered to fall within the scope. It's also the refugees that most of us often maybe think about, those who have a well-founded fear of persecution for one of the 5 grounds in Article 1A2 of the Refugee Convention. And then the third category is refugees under Article 1D, and a subset of them are considered to fall within the Refugee Convention. The purpose of why the drafters included this Article 1D in the Refugee Convention was to avoid overlapping competencies between UNHCR and UNRWA for Palestinian refugees. And that's why this provision was included to exclude them. I mean, the starting point, in principle, they are excluded from the scope of the 1951 Refugee Convention, because there is another framework. But it was also, and that's where the second paragraph comes in, to ensure continuity of protection and assistance for Palestinian refugees whose refugee character has already been established, and but where that protection and assistance has ceased to exist in accordance with this paragraph 2. This is just to say that within the EU Common Asylum Framework, in the EU Qualification Directive, there is Article 12.1a, which replicates the wording of Article 1d in the Refugee Convention. And this is why these 2 cases that I will be referring to went to the European Court of Justice, because they concern the interpretation of Article 12.1a in the Qualification Directive, which is the same as Article 1d. So these cases are called Bol and Elkot and others. And the judgment in Elkot came in late December. So in the first of these judgments, the European Court of Justice was looking at the first part of the article and interpreting what persons receiving protection or assistance from organs or agencies other than UNHCR, what that really means. UNHCR had issued an oral statement. We were not a party to this case, but had issued an oral statement where we had set out our position, which is that these persons include Palestinian refugees from 48 and Palestinian displaced persons from the 1967 conflict and their descendants. And we had also set out that being registered or recorded by UNRWA may help an individual to prove that she falls within the scope of Article 1d, but it's not conclusive. And that UNHCR also considers 1948, 1967 Palestinian refugees and displaced persons and their descendants who are inside the area of operations of UNRWA to fall within the category of persons at present receiving protection or assistance, whether or not, regardless or not of them actually receiving such assistance. So the fact that they are eligible for it was sufficient. This is what we had set out. The Court of Justice said in their judgment in Bolbol that a person receives protection or assistance when that person has actually availed him or herself of that protection or assistance, and that it does not cover persons who are or have been eligible to receive protection or assistance from UNRWA without having actually received it. And on the registration, the Court of Justice said that while registration with UNRWA is sufficient proof of actually receiving assistance, even in the absence of such registration, beneficiaries must be permitted to show evidence that they have been receiving assistance by UNRWA. So, slightly different interpretations. In the El Kot case, there the Court of Justice looked at the second paragraph of Article 12.1a in the Qualification Directive, or Article 1d. And the first thing they looked at was interpretation of what is the meaning of shall ipso facto be entitled to the benefits of this convention, the 1951 Refugee Convention. And UNHCR's position in that was that we interpret this ipso facto to mean that you should automatically be granted the substantive benefits that are attached to refugee status. So the rights in Articles 2 to 34 of the 1951 Convention, that you have an automatic right to those, because we said that otherwise if the provision only means that you can apply for asylum, for refugee status, just like anyone else, what is then the purpose? There must be something more or different meant by the drafters when they refer to this ipso facto entitlement. So we said in our submission that no separate determination of well-founded fear was required. The Court of Justice, though, said that the person must automatically be granted, or that the member state, EU member state, must recognize him as a refugee, provided the person does not fall within one of the exclusion or cessation clauses. And they also said that the person is not necessarily required to show that they have a well-founded fear of persecution within the meaning of Article 1 and 2, but the person must apply for refugee status, and the EU member state must assess whether they actually received assistance from UNRWA and whether the assistance of UNRWA has ceased, and that none of the cessation or exclusion clauses apply. And the Court of Justice also said that the member state must assess all relevant factors, like why it's no longer possible for the individual, for the Palestinian refugee, to benefit from UNRWA's assistance. So in that sense, it's slightly different. It requires more of a determination of the reasons for claiming not to be able to receive assistance and protection from UNRWA than UNHCR had put in our position. Then finally, the second or the other aspect that the Court of Justice looked at was interpretation of when such protection or assistance has ceased for any reason. And in UNHCR position, we said that this includes situation when the person is outside the UNRWA area of operation and cannot re-avail him or herself of UNRWA's protection or assistance for objective reasons outside his or her control. And in our submission, we had also said that this includes persons who left voluntarily, who left an UNRWA area of operation not with the initial intention to seek to become a refugee abroad, but who is then unable to return. For example, if they will not be readmitted, or the situation in their former place has changed, so they can now no longer return. The Court of Justice said that this includes the situation in which a person who, after actually having availed himself of such protection or assistance from UNRWA, ceases to receive it for a reason beyond his or her control and independent of his or her volition. And that the member state must determine through an individual assessment whether the person was forced to flee the UNRWA area of operation, which will be the case, for example, when their personal safety is at serious risk, or it was impossible for UNRWA to guarantee the living conditions in the area of operations in keeping with their mandate. So I think the situation we have in Syria now is an example. But the Court of Justice did not speak out or state its position on the issue of persons who voluntarily depart but who cannot re-avail themselves of UNRWA's protection or assistance. So these different positions that we have are set out in a number of documents. I mean, I'll be happy to email this presentation if you want to see where you can find more substance. But this is what I was planning to say. Thank you.